G'day everyone, my name's Anthony Marinac. I'm a legal practitioner admitted in New South Wales and I've taught law at CQ University in Queensland for a little over 5 years. Welcome to my 2-hour contract course. The idea is that in the space of 2 hours, I want to take you through an entire university course in contract law. Now, a couple of things before we get started. First, this video is great if you're soon to study contract law and you want to get an overview. It's also pretty good if you're studying business or one of those degrees and your interest in contract law is general. Finally, it's pretty good as a way of reviewing your work. However, fair warning, if you're a Bachelor of Laws student, you've done no work at all term, and you're hoping this video can make up for it, well, it will help. But there's no way that a 2-hour video can make up for a whole term's missed opportunities. Now, every time I mention a case or a statutory provision, the citation will come up along the bottom of the screen. You'll need those. The law cited is Queensland law, but contract law is pretty much the same throughout Australia. I understand the law to be correct as at the 31st of March 2018. Okay, so can we do this in 2 hours? Let's give it a crack. Start the clock. The first thing we need to think about is what a contract actually is. Now, there are a few different theoretical models, but my favourite is what's called promise theory. The idea here is that a contract involves 2 or more parties, let's say 2 to make it easy, exchanging promises. You promise to mow my lawn, and I promise to pay you $50 when it's done. A contract is more than just an exchange of promises, though. The special thing about contracts is that if one of the parties doesn't honour their promise, well, then the other party can take them to court and get a remedy. So the court will enforce those promises. This means a contract is an exchange of promises where those promises are enforceable by the court. Now, like I say, there are other theoretical models, but if you keep this idea of promises in mind, the rest of these 2 hours is likely to make a lot more sense. We know, however, that not all promises are enforceable. I mean, people make all sorts of promises all the time, and people are notoriously unreliable. If your partner promises to pick up Indian food on the way home from work but forgets to do so, well, it's a broken promise, but it's not one you can go to court over. So how do we tell which promises are enforceable and which promises are not? To do this, we look at the topic of contract formation. To make a contract, 5 elements have to be sorted. First, you have to have the capacity to make a contract. Second, you must intend to create legal obligations. Third, there must be agreement on the terms of the contract. Fourth, there must be what we call consideration, which means you give something to get something. And finally, the contract must be sufficiently certain and complete. Let's look at each of those in turn. We'll start with capacity. Now, the law's starting position is that everybody is assumed to have the capacity to enter a contract. However, there are a few exceptions. The first and most obvious of these relates to minors, so people aged less than 18. The rule isn't that young people can't make contracts at all. I mean, that'd be silly. It would mean that children couldn't buy a packet of chips or a can of drink. Instead, the rule is that a contract made by a child is voidable. That is, it can be enforced by the child, but it can't be enforced against the child. Let me be clearer. If I make a contract with my 15-year-old neighbour to mow my lawn for $50 and he mowed the lawn, well, he could sue me for the $50 if I failed to pay. Sounds fair. However, if we made that same contract and I paid him, but then he never got around to mowing the lawn, I wouldn't be able to sue to get my $50 back. The law basically says if you make a contract with a child, you do so at your own risk. The reason for this is that children obviously lack maturity, and so often they won't be able to really consider the nature of the obligations they're taking on. So it's a rule that stops young people from being exploited. There are a few situations, however, where contracts can be enforced against a child. The first of these is when the child is making a contract for what we call necessaries. These are things that a young person in their circumstance would ordinarily need. However, you can't even enforce a contract for necessaries if the child already has a good supply of those necessaries. Now, how's the merchant supposed to know that? I've never quite known. However, the rule is that you can't enforce a contract for necessaries if the child already has a good supply. Finally, contracts can be enforced against children if they are what are called beneficial contracts of employment or education. So much for children. What about people with diminished mental capacity? Again, there's no rule against such people entering into contracts. However, the contracts will only be enforceable by them, not against them. The contracts are voidable. A warning though, this rule only applies if the other party knew or ought to have known that they had a mental incapacity. Finally, a very similar rule is in place if a person is so intoxicated by drugs or alcohol that they don't understand the nature of the contract that they're entering into. The thing with these types of incapacity, though, is that they're often not permanent. Children become adults. Drunk people sober up. People with mental incapacity are often restored to full mental capacity. What happens then? Well, if a person makes a contract while they don't have full capacity, but then they later obtain capacity, they have the choice to either repudiate the contract, which means pull out of it, or they can ratify the contract, which means they've now agreed to it while they've had capacity. So it becomes fully binding. Okay, so let's assume that our contract is being made between two people who have full legal capacity. The next thing to ask is whether they are actually intending to create a legal relationship. In other words, do they intend for their agreement to be a contract that can be enforced by the courts? To work this out, the law makes two presumptions. The first is that agreements between family members and others in close relationships are what we call social agreements, and that social agreements are not enforceable by the courts. This makes sense if you think about it, because families make all sorts of promises and agreements within themselves, and it's not the law's intention to jump in every time there's a family squabble. A second presumption is that an agreement which happens in a commercial or trading context between people who are not family and not in a close relationship is a commercial agreement, and that commercial agreements are intended to be enforceable. Both of these presumptions can be rebutted. So it's possible for family members to make business arrangements and enforceable contracts among themselves. It's also possible for commercial agreements to contain what is called an honour clause, which states that the agreement is merely an agreement of honour and is not enforceable in the courts. Okay, so let's now assume we have two parties, they both have capacity, and they both intend to create legal relations with one another. The next thing we need to look for is agreement, which has two elements, offer and acceptance. The idea is pretty simple. One party makes an offer, which means that they indicate a set of obligations that they're willing to be bound by. And they say what they want in return. They can either make that offer to another specific person or to the whole world at large. We need to be careful though, because there are a few things that look like offers, but are not actually offers. First, an advertisement looks like an offer, but it's not actually an offer. An advertisement is what we call an invitation to treat. In other words, an advertisement invites you to make an offer to the store to buy their goods or services. Sounds weird, right? In the same way, if you go into a store and there are goods on display with price tags attached, those aren't offers either. You make the offer when you take the goods to the checkout, and the store accepts your offer when they ring up the sale. There are other weird situations. For instance, what about if you're using a ticket machine or a vending machine? Well, in that case, the machine itself makes the offer, well, strictly speaking, the owner or the operator of the machine makes the offer. And you accept the offer by putting your money in the machine. Same sort of situation with auctions. In an auction, the offer is made by the person making the bids, and the offer is accepted when the hammer falls or when the auction period ends. This includes auctions conducted in environments like eBay. Once that offer is made, a number of things can happen. For one thing, the party receiving the offer might make a counter-offer. This often happens in situations where you are bartering or bargaining. It's very common in house and car sales. In that case, if a person receives an offer and they make a counter-offer, their counter-offer extinguishes the previous offer and they become the one making the offer. This can bounce back and forwards as many times as necessary. Another thing that can happen is that the party receiving the offer can make a request for more information. A request for more information is different to a counter-offer because they're not saying, hey, I reject your offer, but here's my counter-offer. Rather, they're saying, I need more information in order to help me to decide whether to accept your offer or not. Finally, offers can be withdrawn. To withdraw an offer, though, the person making the offer has to communicate that withdrawal to the other party before it's accepted. Once it's accepted, it's too late to withdraw the offer because once it's accepted, you've got yourself a contract. Offers can also be withdrawn if there's a time limit set for acceptance and that time expires. And offers are also withdrawn if the person making the offer dies before it's accepted. Now let's say none of those things happen. An offer is made, there's no counter-offer, no request for information, and the offer's not withdrawn. What happens then? Well, if the person receiving the offer agrees with it in its entirety, then the parties are, as we say, ad idem. That's Latin for of one mind. At that point, the offer disappears in a magic puff of law and becomes a contract. The acceptance of the offer becomes valid when it is communicated to the person making the offer. But there's a bit more to it than that. There are a few different ways in which acceptance can and can't be communicated. First up, acceptance can't be communicated by silence. So you can't say to someone, well, here's my offer. If I don't hear back from you rejecting the offer by 5 p.m. Friday, then I will assume you have accepted the offer. However, beyond that, parties can choose how the offer will be accepted. Perhaps the most obvious way is by signature. Another way in which an offer might be accepted is by conduct. This is how most offers are accepted in the retail world. By accepting your money, giving you a receipt, and bagging up the goods, the store assistant is accepting your offer, and at the same time, they're executing the contract. Now, back in the days when snail mail was still king, the rule used to be that if parties allowed for acceptance to be mailed, then acceptance occurred and the contract became binding when the acceptance was actually mailed. This was called the postal acceptance rule. These days, snail mail is almost a relic of history, and communication is far more likely to be instantaneous communication by email or via a website. The Parliament has established specific rules for when acceptance occurs. Basically, acceptance has been communicated when the message becomes available for retrieval on the recipient's server. One final thing you need to know about acceptance. The acceptance has to be made with knowledge of the offer. You can't just inadvertently accept an offer that you never knew existed. This happened when a murderer confessed his crime. This is the case of the Crown and Clark. The murderer confessed his crime and then sought to be paid the reward for information on that crime. It's absurd, but what tripped him up was not the absurdity of the request, but rather the fact that he didn't actually know about the reward when he made his confession. So he hadn't acted in acceptance of the offer with knowledge of the offer. Crazy case. Okay, so now we have two parties with capacity. They intend to create legal relations, and there's been an offer and acceptance of that offer. Do we have a contract yet? Not quite. You see, there's a difference between a contract and a gift. A gift occurs when a person gives something or does something for another person without agreement that they'll get anything in return. The courts won't enforce a gift. A contract, on the other hand, is always an exchange. You give something and you get something. In legal terms, whatever you give in order to obtain something from the other side is your consideration. This is one of those odd occasions where a word has a completely different legal meaning to its normal English meaning. So to make a contract, both sides have to give consideration. What sorts of things can be consideration? Well, the most obvious types of consideration are money and goods. But there are other types of consideration too. First up, conduct can be consideration. If I agree to pay you money and you agree to mow my lawn, well then my consideration is the money and your consideration is the conduct of mowing. Second, promises can be consideration. So I might pay you money in return for your promise to stop smoking cigarettes. In that case, my consideration is the money and your consideration is the promise. Third, what we call forbearance can be consideration. In other words, you can give consideration by refraining from doing something that you had otherwise intended to do. The most common time you see this in the cases is what we call forbearance to sue. So if you're going to sue me for $25,000, I might make you an offer of $15,000 provided you do not sue me. In that case, my consideration would be the $15,000 and your consideration is your refraining from suing me. So you can see there are various types of consideration. The next thing to consider is how much consideration is required. The rule is that consideration needs to be sufficient but need not be adequate. What on earth does that mean really? Well, it means that the consideration has to have some type of value. So it's referred to as valuable consideration. However, when we say the consideration need not be adequate, we mean there doesn't need to be equal value on each side. If you want to sell me your car for $20, you can. The law of consideration isn't interested in making sure the contract is fair. The law just wants to make sure that each side is giving some sort of real and valuable consideration. In the extreme case, there's what we call nominal or peppercorn consideration. Even a single peppercorn can be good consideration for a contract, provided both sides agree. Sometimes, and this is a bit complicated, entry into one contract can be consideration for another contract. Sounds like gobbledygook, right? Well, let's say I was now heavily encouraging your new lawn mowing business. I learned that my mother was offering you $50 to do her lawns once every fortnight too. But I also learned you were contemplating saying no. I really want you to get into that contract. I might say, listen, I will pay you an extra $10 every time you mow my lawn, provided you agree to enter into that contract with my mum. Can you see how in this new $10 contract, your consideration is actually your promise to enter into the contract with my mum? In this situation, my $10 contract with you is called a collateral contract. A collateral contract is one where one party's consideration is their agreement to enter into another contract called the main contract. Now, that's the fundamentals, but I've got to admit I always found collateral contracts to be a little bit mind-bending. This is probably one area where I would suggest that you really need to go beyond this lecture and read a little bit further. There's one last rule you need to know about consideration though. We call that the rule in Pinnell's case. Basically, this rule only affects contracts of debt, and it says that the payment of a lesser amount is not good consideration to discharge the debt. Let me translate that. If I have a contract with you and you've loaned me $5,000 and I've agreed to pay it back by, say, December the 31st, then we can't agree that by paying you back $3,000, I will have discharged the debt. You'd still be able to sue for that other $2,000, no matter what we'd agreed. It's easy to see why, because if I can use $3,000 to pay off a $5,000 debt, then in effect, you'd be making me a gift of $2,000, wouldn't you? And we know that gifts are different to contracts. There are some exceptions to the rule in Pinnell's case. Let's say you needed money in a hurry. I might agree to pay you back $3,000 by December the 30th in order to discharge the debt. In that case, both sides have given consideration. Your consideration is to give up the $2,000 I would have otherwise paid, and my consideration is to make my payment much earlier than I otherwise would have. See how it works? Okay, we're nearly there. We now have two parties with capacity. They intend to create legal relations. There's offer and acceptance, and both sides have given consideration. The final thing we need to check is whether the contract is sufficiently certain and whether the contract is sufficiently complete. Let's start with certainty. A contract is uncertain when the words of the contract are too vague to enable the court, or indeed the parties, to understand their obligations under the contract. The key case is a good example where one party agreed to buy a motor vehicle on hire purchase terms for 2 years. There were really no more details. Nobody really knew what on hire purchase terms meant. Nobody knew when payments would have been made, or how much those payments would be, or when ownership of the vehicle was transferred. The court was really unable to enforce the contract because the court was unable to understand the contract. It's thankfully pretty rare for the court to walk away from a contract because of uncertainty. The court will make every effort to try to read some sense into the contract. This is particularly so in the case of executed contracts, which are contracts where one party has already fully completed their obligation under the contract. A second strategy the court can use is to refer to some external standard. So it might be that the contract itself uses words that are pretty vague, but overall it describes a situation that's pretty common in that particular industry. If there's a standard way of doing things or a standard set of understandings, the court is quite likely to look at those as a way of filling in the gaps. Finally, in some cases it may be possible to sever the uncertain terms from the rest of the contract. Now obviously this doesn't work if the uncertain terms go to the very heart of the contract, but if the contract can work without them, the court may be inclined to just cut them away and to enforce the rest of the contract. Ultimately though, it's really up to the parties and up to their legal advisors to make sure that the contract is sufficiently certain. Finally, the contract needs to be sufficiently complete. The difference between certainty and completeness is that an uncertain contract covers everything but uses words that really can't be understood. An incomplete contract leaves out important things. So if I made a contract with you to mow my lawn in return for payment, but we didn't specify what that payment would be, well, that's an incomplete contract. A contract which is incomplete may not be a properly formed contract at all. There are a couple of tricks with completeness. First, sometimes parties will make an agreement to agree. So if we made a contract that you would mow my lawn and that after you'd done so we would agree to a price, well, that's really just the same as leaving the price out altogether, isn't it? That contract is incomplete. If, on the other hand, we made an agreement to negotiate, that would be fine. If we make a contract that you will mow my lawn and that I agree that after you've done so we will negotiate in good faith to determine the price, well, that's fine, because my consideration for that contract is not my promise to pay, but rather my promise to negotiate. So an agreement to agree is not okay, but an agreement to negotiate is. Sounds weird until you realise that if there's an unsuccessful negotiation, well, we've fulfilled our agreement to negotiate, but we wouldn't have fulfilled an agreement to agree. You never know whether that second agreement will even be possible. The difficulty with all this is that sometimes, especially when a contract is ongoing, it can be really hard to nail down a price or some other provision that both parties will be happy with. How can parties handle this without the contract becoming incomplete? Well, one way is to give the parties discretion in terms of their promises. So we might make an agreement that for $50 you will mow my lawn every fortnight at 9 AM on Saturday unless I specify another time on the weekend. You can see that gives me a discretion. The only rule with discretion though is that it can't be too broad. A discretion will not be allowed if it makes one party's promise illusory. What does that mean? Well, an illusory promise is a promise that isn't really a promise at all. It's an illusion. So if we agree that you will mow my lawn and that I will have a discretion as to whether to pay you depending on whether I'm happy with the job, that's an illusory discretion. Because I could just choose to pay you $0. In which case, I'm not making a promise or giving any consideration, so there's no contract. See how it all comes together? Finally, parties can agree to refer out certain aspects of their contract to a third-party source, either some other person or some external source of reference. So we might make an agreement that for $50 you will mow my lawn to an adequate standard, and we might insert a provision that if we disagree as to whether the job is adequate, we will jointly pay for the Honourable Chief Comptroller and Inspector of Garden Maintenance to determine whether the job has been done properly. When you think about certainty and completeness, can you see why contracts are sometimes written in a painfully detailed way? It can be really important to have that detail in there so that everyone knows exactly what they're promising. All right, that's the first big chunk of the course done. We now know how to form a contract. We know that you need to have capacity, and we know what happens when contracts are made by someone without capacity. We know that you need to intend to create legal relations, and that agreements between family members usually don't intend to create legal relations. We know that there needs to be an offer, and there needs to be acceptance of the exact terms of that offer, and acceptance needs to be communicated to the person who's making the offer. We know that both sides need to give consideration, but the consideration doesn't have to result in a fair deal. Finally, we know that the contract has to be sufficiently certain and sufficiently complete, but we know that the court will work hard to avoid uncertainty and that there are ways to build in flexibility without the contract being incomplete. So now we've got ourselves a contract. The next thing we need to learn is how the courts will read and interpret those contracts. In other words, what rules does the court use to attach meaning to the words of the contract? Generally speaking, in this second part of the 2-hour course, we're going to assume that we're dealing with a written contract. All the same rules apply in the case of an oral contract, but the rules of evidence are a lot more tricky because you haven't got anything in writing to bring before the court. So assuming a written contract, the first thing to understand is that every sentence or every paragraph of the written contract is a term. We call those express terms because they're expressed in the contract. And we divide those terms into 3 categories according to their level of importance. We call them conditions, warranties, or intermediate terms. Conditions are those terms which are so important that if they were not delivered, the innocent party might as well have never entered the contract at all. These are the terms which really do go to the heart of the contract. So if we made a contract where you mow my lawn and I agree to pay you $50, we can straight away spot 2 conditions in the contract. Your promise to mow my lawn is a condition, because if you didn't mow the lawn, there'd be no point in me entering the contract. In the same way, my promise to pay you is a condition, because if I didn't pay you, there'd be no point you entering into the contract. So if a condition is breached, the contract as a whole loses its value to the innocent party. The opposite of a condition is called a warranty. Now be careful. This is another one of those situations where the legal meaning of a word is very different to its usual meaning in English. In normal language, when we talk about a warranty, we're talking about a guarantee that if something goes wrong, the seller will fix it. In contract law, however, a warranty is a term of the contract that is just a little less important. A warranty is not so important that the contract would lose all of its value if the warranty wasn't completed. So, for instance, let's say that our lawn mowing contract included a term that when you mow the lawn, you'll take away all the clippings and dispose of them. But on the third time you came and mowed my lawn, you forgot to take out the last lot of clippings, and they were left in a pile along the side of my house. Now, obviously that's not great. You haven't completed your side of the contract. But we could hardly say the contract lost all its value to me. I've still got a freshly mowed lawn after all. So why does this distinction matter in the real world? Well, in contracts more serious than lawn mowing contracts, if a condition is breached, the court is more likely to allow the innocent party to get out of the contract altogether. However, if a warranty is breached, the innocent party will still be required to keep their promises under the contract, but they might be paid damages, or they might get some other similar remedy to make up to them the fact that they didn't get what they paid for. Finally, we have what we call intermediate terms. These are terms which sometimes act like a condition and sometimes act like a warranty, depending on the circumstances. So let's say I made 2 different lawn mowing contracts with you on 2 different occasions. Each contract included a term that the mowing had to be complete by midday on the Saturday. Exactly the same term in each contract. Now let's say on each occasion you weren't finished mowing the lawn until 1:30 p.m. On the first occasion it was a perfectly normal Saturday. Nothing particular happening. I was sitting around waiting for the Bombers to smash Hawthorn in the footy. Yeah, so you were late, and yeah, there was a breach of the contract, but it hardly matters really. In that case, the timing provision was acting like a warranty. On the second occasion, however, I decided to sell my house, and I had an open house scheduled for 12:30. And instead of potential buyers turning up to a freshly mowed lawn, they turned up to the sound of a mower and a front yard that looked like jungle. Can you see how in this case the term really was acting more like a condition? If the lawn hadn't been mowed by midday, it might as well not have been mowed at all. That's an intermediate term. The same term has sometimes acted like a condition and sometimes acted like a warranty. Okay, so now we know the different types of term. The next thing we need to think about is how we can tell whether a term is actually part of the contract at all. We call these the rules of incorporation. Obviously, the easiest and clearest way to incorporate words into a contract is by signature. If you sign a contract and you acknowledge that you've done so, then in general terms you'll be bound by what you have signed. This is the case even if you haven't actually read or understood the contract. As long as you knew it actually was a contract, and as long as you signed it, well, you'll be bound by those terms. Unfortunately, not all contracts are nearly as simple as that. There are other ways in which terms can be incorporated. One obvious one is by notice. I'm sure you've all been in this situation where you show up to a commercial car park and next to the ticket booth is a big sign showing a bunch of words which they call terms and conditions. Now that's a bit of a nonsense, of course, because they're all really just terms, but terms and conditions has become the customary form of words. So can you incorporate terms into a contract by a notice? Well, you can, but there are a couple of rules. The first of these is that the notice must be reasonable. So, for instance, a notice board containing 1,000 words of text, which is intended to be read by a driver entering the car park at peak hour, might not be considered to be reasonable. You can imagine the chaos which would ensue if every driver stopped to read all the terms of the notice. In the same way, think about some of those ads you see on TV where there are terms written at the end of the ad, but they're written in text so small that it's virtually impossible to see. That really doesn't seem to be reasonable notice, does it? Second, notice has to be given before the contract is formed. So for instance, let's imagine that you book a hotel room and you pay for the hotel room And then when you get into the room, there's a card showing terms which the hotel wishes to impose on you during your stay. Now those terms won't actually be effective because the contract has already been formed. Offer and acceptance occurred when you paid for your hotel room. Finally, if there are particularly onerous terms in the contract, well, they will require special notice. In the key case of Sperling and Bradshaw, the court said, the more unreasonable a clause is, the greater the notice which must be given of it. Some clauses which I have seen would need to be printed in red ink on the face of the document with a red hand pointing to it before the notice could be held to be sufficient. However, if reasonable notice is given, and the notice is given in time, and the notice is appropriate to the content of the clause, well, then the terms in the notice will be part of the contract. There are some additional special considerations around what we call exclusion clauses. An exclusion clause is a clause which limits the liability of the party who suggests the clause. So in our lawn mowing contract, an exclusion clause might provide that you are not required to mow the lawn if it has been raining in the previous 6 hours, and that a failure to mow the lawn under those circumstances will not be regarded as a breach of the contract. Now, there's nothing inherently wrong with exclusion clauses. They can be a sensible thing to include in contracts to ensure that risks are appropriately apportioned between the parties. However, exclusion clauses can also be used in an evil or tricky way, where one party tries to basically exclude all possible liability which might fall on them if things went wrong. As a result, the law looks at exclusion clauses very carefully. Some of the rules are quite similar to express clauses generally. For instance, if you sign a contract which contains an exclusion clause, the exclusion clause is likely to be effective. In a similar way, if an exclusion clause is put forward by notice, the notice has to be given before the contract is formed. Special rules apply if a party puts forward an exclusion clause but they misrepresent the nature of the exclusion clause. Now, if they do that, the exclusion clause is likely not to be valid. So if, for instance, somebody shows you a page of contract provisions and then they try to play down the contents by saying, don't worry about that stuff, it's just standard boilerplate. Well, that may well be enough to invalidate any exclusion clauses in the contract. Now, even if the exclusion clause does become part of the contract, the court will read the clause contra proferentum. This is a Latin phrase meaning against the person who proffers. So if one party is seeking to rely on an exclusion clause, the court will give that clause its minimal meaning. If there's any doubt as to whether the exclusion will apply or not in a particular situation, the court will read the clause against the person relying on the clause, and the exclusion clause won't be effective. So they have to be written very carefully. Finally, exclusion clauses are bound by what we call the four corners rule. So the exclusion clause will only apply to conduct which is within the four corners of the contract. Anything that happens between the parties and which happens outside the four corners of the contract won't be subject to the exclusion clause. This sounds more complicated than it really is. Let's go back to our lawn mowing contract and let's imagine that contract included a clause which says that you will not be liable for any damage caused to the lawn or the garden or the house, regardless of how that damage is caused. Now, if I agreed to that contract and while you were mowing, the lawnmower spat out a rock which broke my window, it's pretty clear the exclusion clause would protect you because that's happened within the four corners of the contract. It's a mowing contract and you were mowing. But now imagine that you were walking past my house one afternoon and for some reason you decided to pick up a rock and throw that rock at the window and the window broke. The exclusion clause wouldn't help you in that situation because that conduct, throwing a rock at my window while walking past, is pretty clearly outside the four corners of the contract. Okay, so much for written terms. We also have a range of unwritten terms which can be included in a contract. These are still express terms because they're clearly spoken. They're just unwritten. Unwritten terms often occur when there are verbal negotiations between the parties, particularly in sales situations. So how can we tell whether words spoken in the course of negotiation are intended to be binding provisions of the contract? Well, there are a few things to consider. The first of these is the actual words used. The law distinguishes between words which are used to give information and words which are used to make promises. You see, in any negotiations before a contract is signed, it's very likely that information will be exchanged. That exchange of information is not necessarily an exchange of promises. So for instance, let's say that when negotiating our lawn mowing contract, you tell me that you have a large, high quality professional standard lawnmower. Well, that information might impress me, but it's just information. On the other hand, if you said, if you give me this work, then I will use a large, high quality professional standard lawnmower, that sounds much more like a promise, something that I can hold you to. A second thing the court will consider is the relative expertise of the parties. Words which are spoken by a person who has or who claims to have specific expertise are more likely to be considered binding. This is particularly important in sales situations where the seller is likely to have much more expertise than the buyer. In that case, if the seller makes promises about the product, those promises are much more likely to be considered binding. Third, the court will consider whether either party attached any specific importance to the statement. The more importance that was attached to the statement, the more likely it is to be binding. So for instance, let's say we were making our lawn mowing contract and I said to you, it's really important to me that my lawn is mowed by somebody using an electric mower. I don't want anyone using a petrol engine. And then let's say your answer was, well, it sounds like I can definitely keep your lawns in great nick for you. Can you see how I've attached great importance to the electric mower? You haven't actually promised to use one, but your answer, combined with the importance I've attached to my statement, will likely mean that you are bound by a requirement to use an electric mower. Finally, if words are spoken in the formation of a contract, but later on those words are reduced into writing, even if this happens after the contract is signed, well, that'll be great evidence that both parties intended the words to be binding all along. So if after the contract was signed, I sent you an email and said, remember that discussion we had about the motors? And you said, yeah, I remember that discussion. That will be great evidence that we intended those words to be binding. Finally, we need to consider a rule called the Parole evidence rule. This rule says that if there are negotiations between two parties, and then after those negotiations, the parties produce a written contract which they agree is the entire contract, well, then they've obviously chosen which bits of their discussion to put into writing. And only those things which have been written in the contract will be binding. So under the Parole evidence rule, if there's a full written contract, you can't go back to something that was said in the negotiations but they're not included in the contract and claim that the words spoken in those negotiations were binding. The court will take the view that if you considered those words to be so important, you should have made sure they went into the contract. One way to put the Parole evidence rule beyond all doubt is to include what's called an entire agreement clause. An entire agreement clause quite simply says that the signed and written contract contains the entire agreement between the parties. This will stop any suggestion that any other words spoken or any other words included in emails or anything like that are somehow part of the agreement between the parties. Next, lots of contracts include what is called a force majeure clause. This is a special type of clause that says in the event of an unforeseen event, which is beyond the control of either party and which causes a party not to be able to complete their obligations, there'll be no liability. So in our lawn mowing contract, a force majeure clause might operate so that if my home and yard were affected by a bushfire, so there was no grass to cut anymore, well then both parties would be relieved of our obligations. You wouldn't have to mow and I wouldn't have to pay you any more money. The last type of special clause I want to talk about is what's called a choice of law clause. Now you see these all the time, especially on the internet. If you're buying something from an overseas website, let's say one located in Japan, well, which laws should apply? Is the contract governed by Australian law or by Japanese law? If you actually read the T's and C's before clicking accept, you'll find that most of these international contracts include a choice of law clause, stating that the contract is agreed by the parties as being subject to the laws of some particular country. In this case, most likely either Australia or Japan. So now we know how to work out what the express content of our contract is. It includes everything written down in the contract, but it might also include provisions incorporated by notice or unwritten terms provided they meet the criteria. Now let's say there's a dispute about the meaning of those terms. When lawyers talk about the construction of a term, they mean the process of determining its true meaning. When the court is undertaking the construction of a contract, its purpose is to try to figure out what the parties actually meant when they made the contract. However, in a dispute, that's always going to be difficult, because the likelihood is that if the parties agreed on the meaning of the contract, there probably wouldn't be a dispute. So the court starts with the view that if there are clear, express words in the contract, those will prevail. So if the words themselves clearly say one thing, but one party says they mutually intended to say something else, well then in the case of a dispute, the court will begin by enforcing the clear written words of the contract. What if the words in the contract are ambiguous? Well, then the court will look to the matrix of surrounding circumstances to work out what the words mean. But it does so in a very interesting way. The court doesn't look at the matrix of surrounding circumstances and ask what the parties themselves intended. Rather, the court looks at those circumstances and asks what a reasonable person in the situation of the parties would have meant by the words. So in the case of our lawn mowing contract, let's say the contract was for you to mow, quote, my lawn, end quote. You came along and mowed the lawn within my boundary fence, but then you refused to mow the nature strip without extra money, because in your view, that was not my lawn. And if you knew that I'd wanted that mowed, you would have quoted me extra money. My view, of course, is that the price is fair and that it always included the nature strip. The court would consider the circumstances of our negotiation and would consider whether a reasonable person would consider that the words my lawn included the nature strip. Most likely the court would find that when most people mow their lawn, they don't distinguish between their lawn and the nature strip, and that it would have been unreasonable for me to make a contract to get the lawn within my boundaries mowed while allowing the lawn on my nature strip to become overgrown. See how it works? So now we know how to identify the expressed terms of a contract and how to read them. There's an entirely different category of terms though. These are called implied terms. Now, as you might guess, these are not written into the contract. And they're not even spoken about. They're just assumed to be there, or else they're in there because the law demands that they be in there. Let's spend some time looking at implied terms. The first set of implied terms comes from what we call a consistent course of dealing. In other words, if you're in business and over a long period of time you've developed a business relationship with a supplier and you've always done things a certain way and you've come to understand their policies and ways of doing things, then it might eventually reach the point where you're no longer writing everything into a detailed contract for every transaction. Well, in that situation, if a dispute later took place, the court might well take a look at the way the consistent course of dealing between you and your supplier had taken place. And the court might determine that there was an implied term in your agreement that you would both continue to operate that way. Another type of implied term comes from the standard way that things are done in a certain business or industry. If things are done that way universally, the court might be ready to accept evidence that a specific contract between the two parties impliedly assumed that things would be done in the same way. However, to imply this requirement into a contract, the court has to be really sure. It has to be so well known in the industry or situation that everyone entering into a contract in that industry would know of the custom. A third type of implied term is implied into a contract to give it what we call business efficacy. You see, no contract is so detailed that it covers off on every single possibility or every single possible fact that can be relevant to the contract. Sometimes a contract will be sufficiently certain that it actually qualifies as a contract, but then a dispute will happen, and the dispute will be based on things that the parties just simply never turned their mind to. So for instance, let's say you and I made our mowing contract, and then the first time you came round to mow the lawn, the moment you started the mower, I came out to complain about the noise. And my complaint was this: we never said in the contract that you'd be allowed to make so much noise that I couldn't hear my TV. And your response would be, well, that's the noise lawnmowers make. And I might say, well, don't use a lawnmower then. Go and get an old-fashioned scythe or a manual push mower. Your answer would be, well, mowing the lawn that way would take ages and I would want way more than $50. Can you see the dilemma? Well, in a situation like that, the court would most likely imply into the contract a term that you were allowed to use a mechanical lawnmower. Now, there's a danger in this, isn't there? Because by implying terms in this way, the court might actually end up binding people to things they never really agreed to. To prevent that happening, the court has established 5 rules for terms which are going to be implied into a contract for business efficacy. The first rule is that the term must be reasonable and equitable. In other words, the courts are thinking about what's fair in the situation. Second, the term must be necessary. If the contract works okay without the term, then the court will be much less likely to imply a term into the contract. Third, the term must be so obvious that it goes without saying. That's actually the words of the rule. It needs to be blindingly obvious. Fourth, the term has to be capable of clear expression. So the court has to be able to say exactly what the term should have said if the parties had stopped to think about it. Finally, the term must not contradict any express terms in the contract. So these implied terms, they fill gaps in the contract. They don't overturn things which are already in the contract. Now, the implied terms that we've talked about so far are really all about fixing problems with the contract. There's an entirely separate category of implied terms, and these are what we call terms implied by law. So these are terms which the law sticks in your contract whether you like it or not. The first one I want to talk about is the implied duty to cooperate. What this means is that you have to do everything reasonable to allow the other party to have the benefit of the contract. For instance, let's imagine there was a contract for a house sale and some inspections needed to be done as part of the pre-sale process. Well, if this wasn't written into the contract, there would be an implied term that the seller would allow the inspectors onto the premises at an appropriate time so they could carry out their inspections. A second implied duty is the implied duty of good faith. Now, this one's a bit more controversial, but I've never quite understood why. The implied duty of good faith says, essentially, that when you make a contract, you have to do so with the honest intention of keeping your own side of the bargain and allowing the other side of the bargain to keep theirs. You can't prevent the other party from keeping their side of the bargain and then complain about it. So if you came along to mow my lawn and I'd locked you out of my yard, well, I could hardly then argue that you were in breach of the contract because you hadn't mowed the lawn. In fact, you could sue me for the $50 that you should have received on the basis that it was my bad faith that stopped you from mowing the lawn. Next, there are a bunch of terms which are implied into consumer contracts under the Australian consumer law. The Australian consumer law operates throughout Australia by agreement between the Commonwealth and all the state governments. We find the Australian consumer law as a schedule to the Competition and Consumer Act 2010. The consumer law makes a bunch of rules that only apply to consumer contracts. Somebody is a consumer in a transaction if the goods they're buying are worth less than $40,000, or if the goods they're buying are normally bought for personal, domestic, or household use, and they're a consumer providing they're not planning to use those goods in their own business activities. Now, provided you're a consumer, there are some great protections. The first one is that unfair provisions in standard form contracts won't be enforced. Unfair terms cause or take advantage of significant imbalances in the obligations of the parties, and they cause a detriment to the person with the greater obligations. Standard form contracts, of course, are the sort of thing you might normally see as a consumer, where you don't really have any opportunity to negotiate. It's a standard form. However, even in standard form contracts, unfair terms might still be enforced if they are reasonably necessary to protect a legitimate business interest of the trader. The classic example is a contract provision in a gym membership, which enables the gym to toss members out. In this case, they did actually toss someone out after he repeatedly breached the etiquette of the gym. Now, the court found that this was reasonably necessary for the gym to protect their legitimate interests, because other members would withdraw their membership if the benches were drenched in sweat because old mate hadn't used a towel. Elsewhere in the Australian consumer law, we find what are called consumer guarantees. Now, if you've never heard of these, they're really worth a look. Basically, there are three broad categories of guarantee, and then there's a bunch of detail to flesh those out. The first broad category is that there has to be a guarantee of title for anything which is being sold. So when a trader sells you something, they are impliedly guaranteeing that they have title in that object. If they don't, for instance, if it turns out to be stolen, well, you can rely on that guarantee to get your money back. The second broad category is that goods are guaranteed to be of an appropriate quality. They must be appropriately fit for the normal purpose those goods are used for, and they must be appropriately fit for any purpose which the buyer has disclosed to the trader before the sale. Finally, services are guaranteed to be of appropriate quality, conducted by somebody of appropriate skill, and they're guaranteed to be fit for whatever purpose lay behind the service. If these guarantees are breached, the consumer law contains a range of things you can do about it. We'll talk more about those later on in this video when we get to breach and remedy. Alright, suddenly we're halfway there. At this point, we know what you need for contract formation: capacity, intention to create legal relations, offer and acceptance, consideration, certainty and completeness. And now we know how to read the actual terms. We know how express terms work, including exclusion clauses. We know how unwritten express terms work. We know that when the court looks at express terms, they'll implement the clear words first, but look to surrounding circumstances to resolve any ambiguity. We know that sometimes terms are implied into a contract in order to make the contract work sensibly. And finally, we know that sometimes the law itself implies terms into the contract, mostly to keep things fair and try to prevent disputes in the first place. What all of this means is that we now know everything we need to know for a contract to go right. But if contracts always went right, well, there'd never be any legal disputes. In this third section of the video, we're going to talk about what happens when things go wrong. We'll look at mistake, misrepresentation, misleading and deceptive conduct. We'll look at a thing called Estoppel. We'll look at unconscionable dealing, at Duress, and finally, we'll look at illegality. Do you remember when we were talking about offer and acceptance? I said that offer and acceptance result in the two parties being ad idem, or of one mind. Well, what if one of the parties has made some sort of a mistake? What if, for instance, you and I had been discussing our lawn mowing contract and I told you that my place was at 18 University Drive, but you misheard and you heard 80 University Drive. Now, to be on the safe side, you swung by the university and you saw that the yard at 80 University Drive was really quite small. So in fact, quoting me $50 felt like it was a bit cheeky. Turns out though, that my yard at 18 University Drive is huge and it'll take you 3 times as long to mow. The contract itself doesn't include the address, it just says you will mow my yard. This is what we call a unilateral mistake, because only one party, you, have made the mistake. You got mixed up about the address, but I knew the right address all along. Generally speaking, if you make a unilateral mistake, the law won't allow you to rely on that mistake to get out of the contract. The law will say that the person making the mistake should have been more careful. Some unilateral mistakes are a bit more complicated though, particularly where it's a mistake as to identity. Now, I'm blessed with a fairly unusual surname, but let's pretend my name was Anthony Smith. And let's pretend you watched this video and then you had an opportunity to get some law tutoring from Anthony Smith. You signed up for it straight away, and when you were signing up, you said to the organiser, "This is going to be great. I saw Anthony's 2-hour contract law video on YouTube and it was really helpful. Getting tutored by him is too good an opportunity to miss." Now let's imagine that it turned out to be a completely different Anthony Smith. Well, you mightn't have signed up and you mightn't have paid as much if you knew that would be the case. Now that's a unilateral mistake, isn't it? I mean, only one party's made a mistake there. However, when the identity of the other party is a material factor, so when it's an important element of the contract, and when you intended to make a contract with a completely different person, and where the other party ought to know that the identity was important, the contract will be void. When we say a contract is void, it is as though the contract had never been. Now, just to make things slightly more complicated, if two parties are face to face when they make a contract, even if you're mistaken about the identity of the person standing opposite you, the law will still assume that you intended to make a contract with that person, the person standing right there. You've got plenty of opportunity to work out who they are. So a mistake as to identity, a unilateral mistake as to identity, will only save you if the parties are not face to face, and if their identity is an important aspect of the contract, and if you intended to make a contract with someone else, and if the other party knew that. There's one other type of mistake that the law will protect you from. It's a very particular type of mistake we call non est factum. That means it was not done, or more commonly it's translated as it was not my deed. This occurs if you've made a mistake about the actual nature of the document that you've signed. So let's say the document was headed expression of interest, and you signed it believing that all you were doing was expressing your interest in potentially making a contract at some time in the future. As far as you were concerned, all you were doing was handing over your details. In most cases, the law won't help you. You had your chance to read past the headline and to realise the document was in fact a contract. However, if you are from a special class of people, you will be protected. If you're unable to read through blindness, illiteracy, or a lack of understanding of the English language, and you have to rely on somebody else to explain the document to you, or if for some other reason, with no fault of your own, you're unable to understand the nature of the document, well then the contract will be void. Now these are pretty serious barriers to overcome. So really we come back to the basic rule that in the event of a unilateral mistake, it's very likely that the person making the mistake will be held to the contract despite their mistake. Now, there's a second type of mistake called common mistake. It might be called a common mistake, but it's a pretty rare situation. A common mistake occurs when both parties make a mistake as to the existence of some object or some state of affairs, which is crucial to the contract, and where neither party has actually taken on responsibility for the statement that that thing exists. So, for instance, let's say that I'd ordered a book from an overseas bookseller on the internet. While I was waiting for it to arrive, I read some reviews and decided that actually I didn't really want to read that book at all. So I put it on eBay, and you purchased the book before I'd even received it. So the idea was that when I got it, I wouldn't even open it, I'd just forward it on to you. Little did we know that 2 days before you agreed to purchase the book, it was destroyed in a fire at the Overseas Mail Handling Centre. So I sold you a book that didn't exist. You bought a book that didn't exist. It wasn't either of our fault, and we both made the same mistake. In that situation, the contract would be void. You'd get your money back, and we'd go our separate ways. Finally, there's a type of mistake called a mutual mistake. This confuses the heck out of most students because a mutual mistake is different to a common mistake, even though the words common and mutual mean virtually the same thing. A mutual mistake occurs when the parties are completely at cross purposes. So let's say I owned a white sedan and a white ute, and you offered to buy my white car for $10,000. Now, I assumed that you meant the white sedan, because if you'd meant to buy the ute, you would have said, I want to buy a ute. You, on the other hand, didn't even know that I had the white sedan, and you were only interested in buying the ute. Neither of us discover the confusion, so we make a contract for the sale of my white car. I give you the keys to the sedan, and suddenly we have a dispute. Can you see how both sides have made a mistake? But they've made different mistakes. My mistake is that I've misunderstood the car that you wanted to buy. Your mistake is that you've misunderstood which car I wanted to sell. It's not a unilateral mistake because it's impossible to look at the contract and say one of us is right and the other one is wrong. In a situation like this, the truth is that the parties have never actually been ad idem at all. So the contract will be void. So those are our three types of mistake. Can you see how the one thing that unites them all is that all of these mistakes are innocent? The person making the mistake can't really be blamed, and neither can the party who's not making the mistake. Now we're going to get a bit more sinister and look at misrepresentation. This happens when one party is actually trying to lead the other party into a mistake or a misunderstanding. To prove that misrepresentation has occurred, you need to show 5 things. First, you need to show that there has been a false statement about some past or present fact. Now, that generally means that statements about the future can't be misrepresentations. But if I'm selling you a car and I tell you it's never been in an accident, when I know that's not true, then I'm making a false statement about a past or present fact. Second, the statement must be made by one contracting party to another, or by their agent, which means somebody speaking with their authority. So if a friend of mine says to you, you should buy Anthony's car, it's never been in any accidents, well, that won't be a misrepresentation because I'm not the one who said it. But if you asked me whether that was true and I didn't set you straight, well, then there'd be a problem. Third, the statement has to be made at or before the time the contract was made. So if you agree to buy the car and after we've already made our agreement, I say, you won't regret this, this is a great car and it's never been in an accident, then even if I'm lying, it's not a misrepresentation because the contract was already in place when I said it. Finally, the statement has to be intended to induce you into entering the contract, and it has to actually have that effect. So if I can see that you want the car but you're balking at the price, and I tell you falsely that it's never been in an accident, my intention is pretty clearly to convince you to pay the price. If that lie pushes you over the line, well, that's a misrepresentation. So let's say we've met all of those requirements. What is the effect of a misrepresentation? Well, it depends. You see, there are three types of misrepresentation: innocent, fraudulent, and negligent. Innocent misrepresentation happens when the party doesn't know that what they're saying is untrue. They may in fact believe that they're telling the absolute truth. They've just got it wrong. If the other party proves that this misrepresentation occurred, well, the innocent party will be able to rescind the contract. That means that they will be able to set the contract aside and get their money back. But nothing more than that. It's not like the law would want to punish someone who was not actually trying to tell lies. Next, we come to fraudulent misrepresentation. Now, this occurs when someone is just dead set lying. They are making a misrepresentation, and they're doing so either knowingly or without actually believing in what they're saying. Or they're doing it recklessly, that is, without checking into what they're saying and without caring if it's true or not. If a fraudulent misrepresentation occurs, the innocent party can rescind the contract, but they can also potentially obtain damages for any harm they might have suffered as a result of the fraud. Finally, we come to negligent misrepresentation. This happens when one party is under a special duty to make sure that what they are telling the other party is the truth. This is most obvious when the contract is actually for the provision of advice. If you go to, say, a financial advisor, then they're under a special duty to make sure that the statements they make prior to the contract are accurate, because they have access to knowledge you don't. And the whole purpose in going to see them is to obtain access to that knowledge. So if the person making a statement is under a special duty to be reliable and tell the truth, and they fail in that duty, and that failure results in the other party suffering loss or damage, well, then the innocent party can rescind the contract, and they can also obtain damages to undo the harm. Now, under the Australian consumer law, and before 2010 under the old Trade Practices Act 1974, there are in fact statutory provisions which prohibit corporations from making false or misleading statements about a whole bunch of aspects of goods and services. Those provisions, being statutory provisions, carry with them the potential for what's called a pecuniary penalty. That's a fancy way of saying a fine. And in addition to that, a range of other orders might be made under the legislation. Now, mistake and misrepresentation and misleading and deceptive conduct are all great, but they really only apply in a situation where there is a contract. They're also limited to statements about the past and the present. And finally, they're limited in terms of their remedies. It comes down to basically rescission or damages or both. There's another doctrine that comes out of what we call equity law, which is a bit more flexible. It doesn't require that a contract is ever actually formed, and it allows for a wider range of potential remedies. This doctrine is called promissory estoppel. The idea of estoppel is deceptively simple. If you make a statement to someone about a state of affairs, including a future state of affairs, and you intend them to rely on that statement, or you know they're going to, and the statement turns out not to be true, and they do rely on that statement, and some harm comes as a result, well, then you should be responsible for that harm, even if you never actually concluded a contract. So if I was to tell you, look, I'll make a contract with you to mow my lawns, but I want it done well. So you have to go out and buy this particular $1,000 mower, and then we can make our contract. And if you did go out and buy the mower, but I changed my mind then and said, nah, actually, I'm just going to mow myself. You can see that my statement is about a future state of affairs. It turned out to be wrong. You've suffered loss as a result. And it's only fair that I should be responsible for that, even though we never actually had a contract at all. There are 5 elements of promissory estoppel. First, there has to be an assumption or expectation which ultimately turns out to be wrong or invalid or unwisely held in some way. Second, the assumption has to be encouraged or induced by the person against whom the estoppel is being taken. Now, at this point, we need to distinguish between expressing hope and encouraging or inducing an expectation. If I'm encouraging you to buy that lawnmower and I say, I know 3 friends who will also want you to mow their lawn, so you'll make back the cost of the mower in no time, well, that's a representation. However, if I just said, once you've bought the mower, well, I hope other people might get you to mow their lawns too, that's not the same, is it? So a mere expression of hope is not enough. Third, the innocent party has to actually rely on the statement. So if you thought, well, I don't really believe Anthony when he says that stuff about other people getting me to mow their lawns, but I've been wanting to upgrade my mower anyway, so I might as well do it now. In that case, you haven't really relied on my representation, have you? Fourth, the party making the statement must intend for the other party to rely on their statement, or alternatively, they have to know that the other party is relying on their statement. Finally, the innocent party must actually suffer some harm as a result of relying on the representation. Now, if all of those elements are met, then the court actually has a great degree of flexibility in how it might undo the detriment. Sometimes the person making the statement will be required to make the statement come true. So the court might theoretically order me to produce neighbours and friends who want their lawns mowed. Now, that's not really practical in a lot of situations. So instead, the court might order compensation, or it might either order or forbid some other form of conduct with the intention of making it up to the innocent party. All right, now we're going to start getting into the really evil stuff. We're going to start with what's called unconscionable conduct or unconscionable dealing. This is conduct which is so contrary to good conscience that the court just won't allow it to occur. Unconscionable conduct occurs when one person is under a special disadvantage and the other person knows or ought to know about that disadvantage and they take advantage of their superior position. Now, in some cases, as we mentioned right back at the start of these 2 hours, some disadvantages will prevent a contract from being enforceable at all against a child, against a person under a mental incapacity, and sometimes a person who is intoxicated. But there are a lot of other types of disadvantage. So, for instance, in the cases, there's a case called Commercial Bank of Australia and Amadio. In that case, the bank knew that the Amadios spoke no English, and the contract was being explained to them by their son. That sounds fair enough, but it was a contract for them to put their house up as collateral for that son's loan. See the problem? The bank knew the Amadios were at a disadvantage, but the bank proceeded anyway. Then there's a case called Louth and Diprose. Louth was utterly infatuated with Ms. Diprose. She was indifferent to him, but she exploited his infatuation to the tune of many thousands of dollars, despite his relatively low income. You'd have to think that a pub which encouraged a problem gambler to keep playing the pokies might end up in a similar situation. When the court finds unconscionable conduct, the usual remedy is what we call rescission, which seeks to take the parties back as far as possible to the position they were in prior to the contract being formed. So their objective then is to deny the unconscionable party any benefit flowing from their unconscionable conduct. Next, I want to discuss what we call undue influence. This is pretty much what it sounds like. It occurs when a person might have entered into a contract without actually agreeing to the terms of the contract, but rather they've been talked into the contract by the improper influence of some other person. Now, there's a difference between proper and improper influence, a difference between proper influence and undue influence. There's no problem, for instance, with a parent doing everything they can to persuade their child to sign some beneficial agreement or persuade them not to sign some dangerous one. The influence becomes undue when there is an ulterior motive, when the person holding the influence seems to be taking advantage of it. Now, there are two types of undue influence. The first is what we call actual undue influence. This is the simplest. It occurs when there is actual evidence of a person abusing their influence over someone else to persuade them to make some decision. The second type of undue influence is what we call presumed undue influence. This happens when two parties are involved in some type of relationship, and the nature of that relationship is such that the law will begin by presuming there is undue influence. So there's a range of these types of relationships. For instance, parent and child, doctor and patient, lawyer and client, religious advisor and worshipper. You can see that in all of these cases, there's the person with the upper hand, and that person is expected to advise and care about the interests of the other person. You can see how it would look if the person with the upper hand made a contract to their own great advantage with the other person. Don't for a moment, though, think that you have to fall into one of these recognised relationships for presumed undue influence to occur. Whenever the nature of the relationship is such that one person has assumed responsibility for advising and guiding someone vulnerable, the law will presume that undue influence is occurring. Now, if undue influence is presumed, the person with the upper hand will not be able to enforce the contract. However, this is another one of those presumptions that can be rebutted. So if the person with the upper hand can bring evidence to show that they were not taking advantage of their position, and if they can show that the other person had independent advice and they knew and fully understood what they were agreeing to, well, in those circumstances, the court may enforce the contract. But the starting position will be that if undue influence is shown or even presumed, the court will not allow the influential person to take advantage. One step worse than mere undue influence is what we call duress. Duress is where an actual threat is used to secure a contract. This can be a threat of physical harm to a person, it can be a threat of harm to property, and it can be an unlawful threat to a person's economic interests. You have to remember, though, that some economic threats are actually lawful. If a shopper says, "Give me a refund or I will never shop here again," that's a threat to the economic interests of the store, isn't it? But it's really part of the normal cut and thrust of commercial activity. If duress has been used, again, rescission is the likely remedy. Although in some cases, the innocent party might be entitled to what's called restitution, which is basically a repayment to them of any money they might have paid under the contract. Finally, let's talk about illegality. Right at the start of this presentation, I said that the unique thing about contracts is that they are promises which the law will enforce. Well, we'd hardly expect the law to enforce contracts which were illegal, would we? So for starters, any contract to commit a crime, commit a tort, which is something like negligence or civil assault, or any contract to commit a fraud will be void. It's never a contract at all. It's not enforceable by anyone for anything. Next, there used to be a rule that contracts which were contrary to sexual morality couldn't be enforced. And for a long time we thought that rule had died off, but then there was a case called Ashton and Pratt. Mr. Pratt, an extremely wealthy man, entered into an agreement where he promised extraordinary wealth to an ex-prostitute if she would give up prostitution and be available to him. He then died and she sought to enforce the contract. The judge at first instance ruled in part that the contract could not be enforced because it was for a sexually immoral purpose, that of meretricious sex or sex for money. Now, when that case was appealed to the Court of Appeal, it was decided on other grounds, so we still don't really know. what the Court of Appeal thought about the immorality argument. So it may be that contracts which are sexually immoral are still unenforceable. Next, the courts won't enforce contracts which seek to defeat the administration of justice. So if I found out that while you were mowing my lawn you'd also stolen some items from me, I can't make a contract with you that say if you return those items and pay me $1,000 I won't report the matter to police. That's a contract the courts just won't enforce. In a similar vein to protecting the administration of justice, courts won't enforce a contract which seeks to oust the jurisdiction of the court. So if we made our lawn mowing contract and one of the provisions said, although this contract is intended to be justiciable, neither party to this contract may commence legal action against the other party with respect to anything in the contract, well, that part of the contract would be invalid. It's easy to see why. The law is superior to contracts because what makes something a contract is your ability to enforce it in the courts. Now, we have to be careful here because provisions where two parties agree to try mediation or arbitration before going to court, well, they're fine. And a contract where the consideration is forbearance to sue, well, that's fine too. Because in that case, the person forbearing to sue is choosing not to go to court themselves. They're not enforcing that on anyone else. Similarly, if a contract contains an honour clause, remember we discussed those back at the start, well, the honour clause is likely to be valid. Finally, some contracts may be invalid because there are specific provisions in law which invalidate them. So let's say, for instance, a licence was required in order to mow lawns commercially and you didn't have that licence. Well, that means the law says you can't make a contract with me to mow my lawns unless you have that licence. If you do make that contract, well, you may suffer the penalties under the Act, and you also might be liable to me under the contract. Okay, there's one other type of contract clause that I want to discuss. It's always discussed along with the illegal contracts, but it's slightly different. I'm talking about restraint of trade clauses. So let's say I actually had a lawn mowing business and I hired you to be one of my mowers. And in the contract there was a provision saying that if the contract ended, you were not allowed to take any of my customers with you and you were not allowed to mow lawns commercially within 20 kilometres of the business's central depot for 6 months after the end of the contract. Now, sometimes restraint of trade clauses are fair and reasonable, and sometimes they're over the top. The court won't enforce them if they're over the top. How do we tell the difference? Well, the court looks at whether the restraint is reasonably in the interests of the parties and reasonably in the interests of the public. So for the parties, the court will consider things like the scope of the restraint, how long, how far, the activities restrained. So if I stop you mowing, that's one thing, but if I extended that to all landscaping and gardening, well, that might be something completely different. And the court will also consider the bargaining power of the parties. In terms of the public interest, the court will consider things like whether it's going to make it hard for the public to access the service if a service provider is restrained from trading. If the restraint of trade clause is reasonably in the interests of both the parties and the public, it will be enforceable. After all, it's pretty reasonable for me not to want you to take all my customers if we part ways. It's time now for us to think about how the contract might end and what happens when it does. We're going to look at 4 ways in which contracts might end. They might end by performance, by agreement, by frustration, and by breach. Now, if the contract is breached, we'll need to look at remedies. So we're going to look at various types of remedies. Damages, the equitable remedies, and remedies under the Australian consumer law. Once we've done that, we can stop the clock and you'll have completed my 2-hour contracts course. The first and most obvious way for a contract to end is by performance. And really, this is how most contracts end. You mow my lawn, I pay you the $50, and we both walk away happy. There are millions of consumer transactions every day, and every one of them is a contract, and virtually all of them go off without a hitch, and they're performed immediately. There are some rules to know about discharge by performance though. Like everything in contract law, it's never quite as easy as it seems. The basic rule, which is known as the rule in Cutter and Parole, or it's sometimes called the doctrine of exact performance, that rule says that for a contract to be discharged by performance, each party has to absolutely and exactly satisfy their promises. Now, in the case of Cutter and Parole, a sailor died on the voyage home and didn't complete his promise to help sail a tall sailing ship from Jamaica to England. The court found that his widow was entitled to nothing because he hadn't fully completed his promise. Now, it seems to me that the rule in Cutter and Parole is a good place to start. I mean, as a general principle, what you promise, you ought to do. However, it's not too hard to imagine situations in which the rule in Cutter and Parole could result in some real injustice. So the law has developed some exceptions to rub off some of the sharp edges of the rule. The first one of those is what we call the divisibility exception. So if a promise can neatly and realistically be divided up, then the person might be paid for those bits which they did complete. So if you and I made a contract where you agreed to mow my lawn 5 times for $50 each time, that's pretty clearly divisible. So if you were only able to do it 3 times, you could still ask for $150. Now, if we made a contract for you to mow my lawn 5 times for $250, that's slightly murkier. Can you see the difference? But it'd still probably be divided. If, however, we made a contract for you to maintain my lawns for 3 months for $250, that's much less easy to divide. See how it works? A second way around the rule in Cutter and Parole is expressed in 2 closely related ways. It's sometimes called the de minimis rule, and it's sometimes called the doctrine of substantial performance. De minimis comes from the Latin saying de minimis non curat lex, which means the law does not care about trifling things. In other words, if a party's obligations really have been substantially performed, you can't just go out and nitpick some ridiculously tiny failing and use that as the basis to deny them the whole of their payment. Now, you might still be able to seek damages depending on how truly trivial the failing is. However, if a contract has been substantially performed, the court is going to overlook some trifling failing rather than allow the rule in Cutter and Parole to operate unjustly. A third way around the rule in Cutter and Parole is called the doctrine of part performance. Now, this is a bit different to divisibility or substantial performance because it relies upon the agreement of the innocent party. Essentially, the innocent party can accept part performance of the contract as long as they do so freely, and that'll stop them from relying on the rule in Cutter and Parole. So let's say we had our contract for you to mow my lawn 5 times for $250, and our practice had been that I pay you $50 every time you mow the lawn. This happened 3 times, and then you called me and said, Anthony, my studies are getting a bit overwhelming and I'm really not sure I can keep mowing the lawn. In return, I said, fair enough, thanks for your help thus far. Now, if the rule in Cutter and Parole applied, I'd be able to demand my $150 back. I mean, you haven't completed your total promise, therefore you get nothing. Under the doctrine of part performance, though, I've volunteered for this, so you get to keep what you've earned to this point. Now, one last thing about discharge by performance, and this goes back to a concept we mentioned earlier about the duties of cooperation and good faith. You can't obstruct the other side's performance of their obligations under the contract and then try and rely on the rule in Cutter and Parole to relieve yourself of the duty to pay them. In fact, if that happened, it would be very likely that they would have an action against you for breaching the implied good faith term in the contract. So if a party absolutely completes their contractual obligations, or if one of the other exceptions to the rule in Cutter and Powell apply, then the contract will be discharged by performance and everyone goes away happy. A second way that a contract might be discharged is by agreement. There are a few ways in which discharge by agreement might work. The first is where the contract itself contains an agreement about when and how the contract might end. This is actually pretty familiar to most of us. If we sign up to rent a house, the lease has an expiry date. If we sign up to a gym or an online dating service or a phone contract, well, these all have expiry dates. So after the expiry date is met, either party can pull out of the contract, usually with some notice, and both parties walk away happy. A second way in which a contract can be discharged by agreement is by what we call the failure of a condition precedent. Sounds more complicated than it is. In this situation, the parties have agreed that their obligations to one another, so their contract, will commence if and only if some prior event occurs. So let's say you're living in Sydney and I'm here in Rockhampton, but I know your intention is to move to Rockhampton. I might say to you, look, let's make a contract for you to mow my lawn every 3 weeks for $50. But your move to Rockhampton will be a condition precedent. So if you don't move to Rocky, the contract won't come into being. But if you do move to Rocky, then the contract will be established. See how it works? Now, the most common place that you'll find these condition precedent clauses is any contract which relies on finance. So you might agree to a contract to buy a house, but the contract will be subject to finance. If you don't get the loan, you don't have to buy the house. The loan, in that case, is a condition precedent. A third way in which a contract can be discharged by agreement is called a condition subsequent. So we have a condition precedent and a condition subsequent. Now, if a condition subsequent occurs, then that will end the contract. So let's say when we make our lawn mowing contract, you say to me, look, Anthony, I really appreciate the work, but I'm also applying for other weekend work, and if I get one of those jobs, I won't be able to keep mowing the lawn. So we put in the contract a condition subsequent, saying that if you get other employment on the weekends, the contract will be terminated. If you do get work, the contract is over and we're all happy. If you don't get work, well, then you keep mowing the lawns and we're all happy. Now, it's easy to get confused between conditions precedent and conditions subsequent because they work in opposite ways. A condition precedent is something that must happen if we want the contract to continue. A condition subsequent is something that must not happen if we want the contract to continue. Finally, of course, parties can simply agree to end their contract. This is called termination by accord or release, and it's a type of termination by agreement. So now we know two ways for contracts to be terminated, by performance and by agreement. Next, we're going to turn to termination by frustration. Now, frustration, of course, is an emotion which most law students know well. But in contract law, it has a particular meaning. Frustration occurs when some external event happens, something outside the control of either party. But the effect of that is to completely change the nature of the bargain, so that now the party's obligations under the contract mean something completely different to what the parties understood when the contract commenced. This is one of those concepts that's a lot easier to understand once you see some examples. So let's look at a few. The first one is the destruction of the subject matter. The classic case here was called Taylor and Caldwell, which was a contract for the hire of an amusement hall. Taylor and his compatriots went to some expense to prepare and advertise a range of events at the music hall, from which they intended to make money. But through no fault of Caldwell's, the music hall burned to the ground a week before the event. Taylor then sued Caldwell for failing to provide the venue. But the court found that the contract was frustrated. Promising to hire out an amusement hall, becomes a completely different type of promise when the amusement hall burns to the ground. Another case, Morgan and Manser, was a case where a music hall performer received a contract to perform, but then he was called up for service in the Second World War. As a result, the contract was frustrated. It was neither party's fault, and the contract became impossible to perform. A third case is one of the famous coronation cases. It's called Krell and Henry. Henry leased 2 rooms and balconies from which somebody could watch the king's coronation procession. But the procession was then cancelled because the king got sick. Now, the renter could have still used the balconies, but there was nothing to see. The whole basis of the contract had been destroyed, and it was neither party's fault. See how it works? Now, there are a couple more things to know about frustration. First up, a contract doesn't become frustrated just because honouring the contract turns out to be a lot more inconvenient or expensive than was initially expected. It has to be rendered a different contract, or the performance has to become performance of a completely different type. Second, frustration only affects future obligations under the contract. Any obligations which fell due before the frustrating event are still enforceable. So if we think about Morgan and Manser, if the contract had been for 10 performances and he received his call up to join the army after the 3rd performance, well, both parties' obligations in relation to those first 3 would be enforceable. The second thing to ask is what the consequences are if a contract is frustrated. Now, it all depends on whether there has been what we call a total failure of consideration. In other words, has either side given consideration for something and got absolutely nothing back in return? In that case, they may be able to recover their consideration. However, if there has been some form of consideration in return, any sort of consideration at all, then the losses will lie where they fall. The parties just walk away from the contract in whatever circumstances they happen to be in at the time of the frustrating event. Now, this of course can result in injustice, and in New South Wales, South Australia and Victoria, the Parliament has made laws allowing the court to try and find a fair outcome in the case of frustrated contracts. Finally, it's time for us to talk about a breach in the discharge of a contract. How does a contract end when someone just doesn't keep their promise? Well, in the first case, if there's a failure to perform, we have to look way back to the second part of this lecture and think about whether it's a condition or a warranty or an intermediate term that's been breached. If it's a condition or an intermediate term that's acting like a condition, then a breach will give the innocent party the capacity to end the contract. If it's a warranty or an intermediate term which is acting like a warranty, well, then the contract will continue, but another remedy such as damages will be available. So how do we know when there's a failure to perform? Well, that very much turns on the contents of the individual contract. If the promises are delivered on, well, there's no breach. If promises are broken, there's a breach. The party alleging the breach will need to prove that it occurred. It's not that complicated, really. The more interesting breach cases involve what are called repudiation and anticipatory breach. Repudiation occurs when a party simply turns around and says, I'm not going to be bound by my promise anymore. So it's different to a normal breach where a party just hasn't completed their obligations. If Saturday came along and there was no sign of you and your mower and I called to say, hey, where are you? And your answer was, look, you can keep your money. I'm not mowing your lawn. It's hot and dirty and there's cricket on the TV. Well, you would have repudiated the contract. Now, if you repudiate the contract, there's a number of things I can do about it. I can terminate the contract, of course, but I don't have to. I can leave the contract on foot if I want and demand that you either meet your promise or pay me damages for failing to do so. A third type of breach is a special breed of repudiation which we call anticipatory breach. This happens where the time hasn't yet come for someone to deliver on their promise, but it's clear to you that they're not going to. Well, in that case, you can terminate the contract for breach and sue for damages immediately. You don't actually have to wait for the breach to occur. This happened in the great yo-yo case, Hammer and Barrow against Coca-Cola. Hammer and Barrow were manufacturing those cool Coca-Cola yo-yos which used to be all the rage back when I was at school. Coca-Cola ordered 200,000. The first batch of 85,000 was delivered, and from those, 60,000 were defective. Coca-Cola didn't have to wait for the other 115,000 to be delivered before ending the contract and suing for damages. Otherwise, heaven knows how many defective yo-yos they'd have had on their hands. Okay, so we've got a breach. What sort of remedies can we get as a result of the breach? During this video, you've heard me talk from time to time about damages. And damages are the primary form of remedy under the common law. Damages are essentially the payment of money which seeks to compensate the other party for the harm caused by the breach. Now, how is the damages calculated? Well, in some ways that's a matter for the court and a matter for the evidence which each side brings to the court about what the extent of the loss was. But there are 4 key principles. First, damages are calculated at the date of the breach, not at the date of the trial. This is important because sometimes it can take a long time for a matter to come to trial. And if we're talking about something like real estate or commodities, then the value of those might change quite considerably between the time of the breach and the time of the judgment. Second, damages are calculated on a once and for all basis. So if a party gets an award of damages, the award of damages will completely settle the liabilities between the parties in relation to that breach. If it later turns out that the damage was worse than expected, you can't go back for more. Damages are a one-off, once and for all award. However, when calculating those damages, parties are in fact allowed to claim for what are called expectation damages. So for instance, if a party is unable to make the expected profit because of a breach, well, they can claim damages for that lost profit. If they've missed out on other opportunities because they invested their resources in the breached contract, they can potentially claim for those lost opportunities. Finally, the parties don't need to leave it to the court to decide what the damages are going to be. In fact, many contracts actually set out what the damages are going to be in the event of a breach. These are known as liquidated damages. And there's nothing wrong with this. The court will enforce that liquidated damages clause even if it results in different damages to what the court would have chosen. The only time that the court won't enforce that liquidated damages clause is if it's so outrageous that it becomes what we call a penalty. So it functions more as a punishment than merely as a form of compensation. Now this might sound obvious, but you can only get damages for the harm which is actually caused by the breach. How do we tell? How do we distinguish harm which was caused by the breach from other sorts of harm that might have other causes? This issue is called causation, and we apply a rule called the rule in Hadley and Baxendale. It has 2 main questions which are known as the 2 limbs. First, it asks whether the harm arose naturally from the breach in the normal course of things. In other words, if it's self-evidently obvious that the harm arose from a breach, then causation is proven. Second, it asks whether the harm is a type of harm which was reasonably within the contemplation of the parties at the time of the contract. And if it was, well then the harm can be considered to have been caused by the breach. Let me give you an example. Let's say I had received a letter from my local council telling me that my lawn required work and that if I didn't have it mowed by the 1st of June, well then I'd be fined under the bylaws. And so I contact you and we make a contract for you to mow my lawn no later than the 31st of May. And I tell you that the reason I'm hiring you is that the council is threatening to fine me if I don't mow the lawn by the 1st of June. Now let's imagine that for one reason or another you didn't mow the lawn until the 4th of June and I got a fine. Can you see that your breach has caused me to be fined? And the possibility of that fine was within our contemplation at the time of the contract. I'd most likely be successful in suing you to recover the amount of the fine. Now, there are a couple of things to consider on the other side of this whole equation. You see, even the innocent party might have some obligations in the event of a breach. The first obligation is what we refer to as mitigation of loss. So if someone else's breach has caused you a loss, but there are reasonable things that you can do in order to minimise that loss, then you may not be able to claim for the whole loss. So let's go back to the scenario we used a moment ago. And let's say that on the 27th of May, you contacted me and said, Anthony, I'm not going to be able to complete our contract before the 1st of June. Let's say the fine was going to be $400. What can I do to mitigate my loss? Well, I could go out immediately and ask another mowing company to come around the next day and do the mowing. But because of the short notice, they're going to charge me $120. Under contract law, what I should do is pay the $120 and then seek damages from you of $120. Because by doing that, I have mitigated or reduced, and in this case removed, the risk of the $400 fine. So I'm obliged to take those steps to mitigate my loss, but the costs of that mitigation can be recovered in damages. In the same way, if I pay money to repair or rectify something that was damaged or left undone by your breach, well then I can generally recover the money which was properly spent on that rectification or repair, provided it was reasonable and necessary. Alright, the clock's ticking on us now, but I reckon we'll get there. The other thing that might affect the innocent party in terms of damages is what we call contributory negligence. This occurs when something done negligently by the non-breaching party causes an increase in the harm from the breach. The classic case was called Lex Mead and Lewis, where a farmer bought a defective towing hitch and continued to use it even after he knew it was defective. When the hitch broke and caused an accident resulting in 2 deaths, part of the fault rests with the supplier of the defective hitch, but the farmer's contributory negligence also counted because the farmer continued to use that hitch even after he knew it was defective. So can you see, if your own negligence contributes to the harm, you can't get damages for all of the harm. Okay, so much for damages. A second type of remedy is what we call restitution. Restitution is based on the idea that if a person is unjustly enriched by their breach of a contract, they may have to pay restitution to the other party to offset that enrichment. So let's say you came round and mowed my lawn, but then I discovered that the contract was actually illegal. Because let's imagine that to mow lawns for a profit, you need an Australian business number, a licence and a paid up insurance policy. And you didn't have those. Now on that basis, the contract would not be enforceable. So I could wait until after you'd mowed the lawn and then refuse to pay. Because the contract is unenforceable, you wouldn't be able to do anything about it, right? Well, under the principles of restitution, you might be able to claim the payment for the work that you have done, because otherwise I would be unjustly enriched. It would be against good conscience for me to keep the money, but also have the benefit of your labour. Now let's look at some of the equitable remedies that might be available to a court. Remember, it's a basic principle of law that equity follows the law. So if damages are going to be reasonably capable of compensating a party for harm, well then damages will be the remedy ordered by the courts. However, if damages are not an appropriate remedy, the court may consider a number of remedies in equity. The first one to mention is called specific performance. This is where the court orders the breaching party to fulfil one or more of its obligations under the contract. The most common example occurs in real estate sales. If a party refuses for one reason or another to sign the transfer in the sale, then the other party, the plaintiff, can seek an order for specific performance, where the court would order them to sign the transfer. Now, to make an order of specific performance, a couple of requirements have to be met. First, the court has to be able to set out very precisely the performance to be specified, and that in turn means it has to have been set out very clearly in the contract. Second, it has to be a single one-off obligation to be performed. The court will not order specific performance of any obligation which would then require ongoing supervision by the court to see whether the order was being followed. A second equitable remedy is almost the polar opposite of specific performance. This is called an injunction. Generally, an injunction is an order by the court that a party must not do something. But it can also sometimes be an order that a party must do something, even if it's something not specifically set out in the contract. So for instance, let's say we made our lawn mowing contract, and as part of that contract, you agreed that you would not contract to mow anyone else's lawn on Saturday mornings. And then I found out you were doing so. Well, I might seek an injunction to stop you from mowing that other person's lawns. Quite often, injunctions are used on what we call an interlocutory basis, which means the court might make an injunction at the very start of a proceeding, well before the matter comes to trial, in order to stop the harm from growing in the time that it will take to get to the actual trial. So for instance, a person who was alleged to have been telling trade secrets might find an interlocutory injunction prohibiting them from making blog posts about the industry until such time as the court can work out whether they really have breached the contract by telling trade secrets. The final type of equitable remedy that I want to discuss is called rescission. Rescission is an equitable remedy which seeks to bring the parties back to their positions prior to the contract. So it tries to undo the contract from the very beginning. So imagine a contract for the sale of a defective product. Well, rescission would occur if the court ordered me to give back the product and the store to give back my money. In many cases, of course, rescission is not practically possible because under the contract, people may have done things that can't be undone. So for instance, in our lawn mowing contract, you can't unmow my lawn. So rescission is not practically possible. Now, once upon a time, that would have been the lot for remedies. However, earlier in this video, I talked a little bit about the Australian consumer law, particularly in relation to misleading and deceptive conduct, and also in relation to the consumer guarantees that are implied into consumer contracts. If the Australian consumer law is broken, then the consumer law itself provides its own remedies. Any breach of those consumer guarantees will be classified as either a major or a minor failure. A failure is major if it means that the goods or services are unsafe, or if they depart substantially from the description which was initially promised, or if there is a failure so substantial that the consumer wouldn't have purchased the goods or services if they'd known of the failure. Now, if a failure isn't major, if it doesn't meet those descriptions, then it's minor. In the case of a major failure, the consumer can reject the goods or services, or alternatively, they can take legal action under the Act to recover any lost value. So that is the difference in value between the product as it is and its value if the failure had not occurred. If the failure is minor, then it's the supplier who gets the options. They have the option of replacing the product, repairing it, or refunding the cost price. Now, those are the remedies that the individual consumer can go after under the Australian consumer law. In addition, there are some remedies that can be sought by the Australian Competition and Consumer Commission on behalf of consumers of that product generally. These measures can include pecuniary penalties, so financial penalties. They can include a compensation order, that compensation be paid to customers. They can include an injunction to prevent the supplier from continuing to breach the Australian consumer law. And they can include what's called an enforceable undertaking, where the supplier agrees to some course of action which is intended to rectify the harm caused by its product, and where the ACCC can take further action against the supplier if the undertaking is not delivered on. Oh my goodness, here we are. We've looked at how a contract is formed by two or more parties with capacity, who intend to create legal relations, who have offer and acceptance, who give consideration, and whose contract is sufficiently certain and complete. We've looked at express terms, including exclusion clauses and unwritten express clauses. We've looked at implied terms, whether they're implied to fill in gaps in a contract or whether they're implied as a matter of law. We've looked at factors like mistake, misrepresentation, undue influence, unconscionable conduct, and illegality, all of which can make a contract void. And we've looked at contracts ending by performance, agreement, frustration, and breach. And if there's a breach, we've looked at the common law remedy of damages, we've looked at the equitable remedies, and the remedies under the Australian consumer law. Stop the clock. I really do hope this has been helpful to you, either as a brief overview and introduction to contract law, or as a basis of revision if you've studied this material already. If you found it to be useful, please keep an eye out for future 2-hour courses, because I'm hoping this one won't be the last. And please do think about clicking on those pesky ads from time to time. I'd love to be able to get some better cameras and mics and give you all a better learning experience. For now, may all your contracts be fruitful.